Okay, we are now 1 minute past. I thought I'll kick things off with saying hi and welcome to this, the last seminar of the season from the Stockholm Chamber of Commerce Arbitration Institute. This time we are going to be talking about one of the more core topics for us, which is how do you negotiate a dispute resolution clause? And we're going to be going through it. And I will, before I jump into that, I'm just going to give the intro that I'm sure you've heard in a couple of webinars by now, which is we are recording this. So we might be putting this on a social media channel near you in the future. So be aware of that if you ask questions and so forth. And also, please do ask questions. We will be answering them both throughout and towards the end, depending a little bit of where we think that they fit. You have both a chat function, which I see has already started a little bit, which I love. Please do go on and say hi to each other in the chat function, comment to us or to each other. And please note that when you do, you can choose whether you want it to be just the panelists, which will be me and Christoffer and our IT guru, who is the man in the black box in the little window there, or if you want everybody to see it. So you see that on the little drop-down menu that you've got there. And also there's a Q&A function if you want to ask questions. And as I said, we'll address them throughout and also towards the end. So with that little intro, I'll briefly run through what we will be talking about today. So we are going to give you first a short intro of the SCC. We know that we have quite a lot of guests from all over the world, which we're really excited about. And some of you guys will know us well, and some of you will know us less well. So we wanted to just briefly introduce you to who we are and what we do. And then we will go through the components of the midnight clause. So essentially the dispute resolution clause. The reason why it's called that, of course, is that, to be honest, nobody thinks about this before midnight. And then we'll finish off with things to remember and the things that you need to remember from this. No, sorry, things to avoid and things to remember. But before we do this, I wanted to also introduce myself and then give the word over to Christoffer to introduce himself. My name is Lise Alm, and I am head of business development at the Stockholm Chamber of Commerce Arbitration Institute. And I'm a lawyer by trade, but I'm actually not I didn't start in arbitration and litigation, but rather in M&A. And then I was at Spotify for a number of years working with M&A there and corporate aspects, and then moved over to other startups after that before I rejoined at the this world at the SCC for about 2.5 years ago. My role at the SCC is to look at the world and see where I think we're heading when it comes to commercial dispute resolution, what the tools of the future will be, whether or not what our role should be in that world, and how we can help make sure that we always have the best tools available for making sure that you spend as little time as possible handling disputes. So that's a little bit about me, what I do and who I am. And with that, I will hand it over to Christoffer.
Thank you very much, Lise, and hello, everyone. So my name is Christoffer, and I am a legal counsel at the SCC. And prior to joining the SCC, I worked as an associate at an international corporate law firm and also in one of the district courts in Stockholm. And I look forward to speaking a bit to on this subject and also to have a nice discussion.
I should say as well that what you can see on the lower end here of the slide is essentially a time bar for how long we will kidnap you. Normally it's a webinar, so we know that you could drop off. But normally, if we were doing this live, this would be the countdown line here, where you can see exactly where we are and how much further we have to go before you're fully trained on everything negotiating a dispute resolution clause. Okay, so.
Yes, so this is me. And as Lisa mentioned, in order to kind of start this seminar off, I would like to say a few words about the SCC as an arbitral institution. And the Arbitration Institute of the Stockholm Chamber of Commerce, which is also known as the SCC, is, as its name implies, an independent part of the Stockholm Chamber of Commerce. And the SCC was founded in 1917, which makes us one of the oldest arbitral institutions worldwide. And in the beginning, the SCC was established as a service to the Stockholm Chamber of Commerce. And in the beginning, this service was primarily aimed at companies in the Stockholm region. But as many as you probably know, this has changed over the years, and today the SCC is a truly international institution. The SCC handles about 150 to 200 cases per year, and on average, the SCC has handled about 190 cases on average per year during the last decade. About half of our cases are international, which often means that they have no connection to Sweden except for perhaps the seat of the arbitration, which we will be talking more about, and the agreed application of the SCC rules. And parties from about 40 to 45 different nationalities are in fact represented in the caseload. The cases handled by the SCC are very diverse in nature, I would say, but there are some characteristic case types present in our caseload. And some that I would like to mention are disputes between East and West countries, investment disputes, and energy disputes. The SCC also maintains a number of different rules which the parties may agree shall apply to their dispute. And the most used rules are the SCC arbitration rules, which apply to the majority of our cases. Another set of rules which are aimed at smaller disputes and provide for a quicker arbitral proceeding are the SCC expedited rules. And these are also quite common. In fact, during last year, about 60% of the cases administered by the SCC were registered under the arbitration rules, while about 30% of the cases registered were under the expedited rules. Let's just change the slide here. There we go. So after that brief introduction, I would like to kind of jump into the main subject matter of this seminar, mainly the core components in a dispute resolution clause, or the midnight clause. And I think Lise explained quite well why it is sometimes called the midnight clause. Because this is a clause that is also usually found on kind of the last page of any commercial contract, which is usually negotiated at the very end of contract negotiations. And of course, this implies a risk that perhaps not enough attention will be given to a clause which will in practice turn out to be very important should a dispute arise in the future regarding the contract. So looking at the core components here, I think that the obvious first question to consider when drafting a dispute resolution clause will be to decide whether a dispute shall be resolved by way of national court proceedings or arbitration. And after this, if it is agreed that dispute shall be resolved by way of arbitration, the second question will usually be whether ad hoc arbitration or institutional arbitration shall be utilized. And we will be talking a bit more about the difference between, on the one hand, court proceedings and arbitration, and on the other, the difference between ad hoc arbitration and institutional arbitration. So, should the parties agree that a dispute should be resolved by way of arbitration, this brings us to the component of the dispute resolution clause that I would say is perhaps the most important, which is the seat of the arbitration. And the seat of the arbitration is a very important concept in arbitration law in general, because the seat brings with it a number of legal consequences. So why is it so important then? Well, first, the seat of the arbitration determines the law of the arbitration agreement, which is also the law governing the arbitration procedure. And consequently, the law of the seat will govern the procedural aspects of the arbitration, but not necessarily the law applicable to the merits of the dispute. The seat also determines where an award may be appealed, which part of the award may be appealed, and the applicable enforcement process. That is the rules and requirements regarding the enforcement of an already rendered arbitral award. Another point here is that the law applicable to the arbitration agreement determines whether the matter in dispute is at all arbitrable, that is, whether the dispute may at all be adjudicated by way of arbitration according to the law of the seat. And considering all of this, it becomes quite evident that the seat is in fact a crucial component when it comes not only to the arbitral proceedings as such, but also the actual value of the award once it has been rendered. Something to be noted here when talking about the seat of the arbitration is that the seat should not be confused with the place where the hearing of the arbitration actually take place, because these are different things, although they often overlap in practice. Because the tribunal, the arbitral tribunal, may, together with the parties, decide that the hearing in the arbitration shall in fact take place somewhere else than the seat of the arbitration. So proceeding then to the next kind of core component here. Yes?
May I add just a comment to that?
Of course.
One of the first tips here. So when it comes to seat, I gotta admit, since I'm a former in-house lawyer, I've been negotiating, from writing these clauses quite a few times. I must say I haven't always been super conscious when I have drafted them. It's in my former past life, so hopefully I'm forgiven for it. But I know that that's quite often the case. And I must admit that when I did try to negotiate this, I didn't pay too much attention to seat, because in all honesty, I thought it was what you just said, Christoffer. It's where you go to have your conference, where you go to have the hearing. So it's more about, do I like Paris in spring, or, so I didn't pay too much attention to it. This is really the one to hold on to. And since I know that not too seldom a negotiation here will be some sort of tit for tat, you will have, you get that if I get that, you get this if you get that, hold on to the seat if that happens. So that's kind of one of the first things to go, but you can let go of a few other things, and we'll come back to the things you can let go to and what are a couple of fallback options that are, honestly just as good. But hold on, if you do have arbitration, do hold on to the seat. So we'll come back to what that means, but just wanted to underline that.
Yes, thank you, Lisa. I think that's a very good comment. The seat is very important. With that said, the rest of the core components here should also be considered when drafting the dispute resolution clause, of course. And the next one on the slide here is that this becomes relevant if the parties have decided on institutional arbitration as opposed to ad hoc arbitration. And if this is the case, it is quite important to specify which arbitration institution should administer the proceedings, and also the rules that shall be applied to the procedure. Also, the considerations to be made when choosing an arbitral institutions is something that we will be coming back to during this presentation. Wow, now we got 2 points here. The next point is choice of substantive law, and this is the law governing the main contract in which the dispute resolution clause is included. So this is the law that will determine the law applicable to the merits of the dispute, and it's therefore important to kind of choose a substantive law that the parties are comfortable with. And usually this will be a law from a jurisdiction similar to that of the parties. So if you are, for example, from a civil law jurisdiction, you might not want to negotiate a dispute resolution clause according to which the contract shall be governed by laws from a common law jurisdiction, because that might be unfamiliar. Something to note here is also that it will, of course, be necessary to choose a substantive law, regardless of whether the dispute shall be resolved by arbitration or court proceedings. But in terms of court proceedings, the choice of law will, in practice, be limited to the law of the country of the court proceedings, I would say, whereas in arbitration, this is more flexible. Depending on the parties and the matter of the dispute, one additional note here also is that it may be wise not to choose the substantive law of a small jurisdiction, which has recently undergone major legal changes. So proceeding to the next point on this slide, another important component in the dispute resolution clause is language. And this is, of course, especially true in international cases. And besides affecting the parties and their representation, the language of the arbitration must also be considered when appointing arbitrators, because arbitrators must be able to understand the language of the dispute in order to determine the case, and must also be able to render an award in the selected language. And regarding substantive law and language, I mean, these are very important points, but this is not something that we will elaborate on during this presentation, because it basically comes down to the parties and the dispute at hand.
I can just say one thing when it comes to choice of law. We do see issues of, I mean, this one is one of the stronger arguments for negotiating this slightly before midnight, because when this is thrown in at the end, when you flip the language, the choice of law towards the end of the contract, you may have negotiated it based on not assuming that there are any obligatory rules or mandatory legislation in the jurisdiction that you're in, and then towards the end you flip it, and all of a sudden it may actually undermine some of the things that you negotiated earlier. Whereas some of these other things you can more negotiate in a silo. Seat is easier to negotiate in a silo than choice of law, of course. And I mean, I assume we have quite a lot of lawyers here, so this will be an obvious point, but we still do see disputes that have arisen out of that fact, that it's been kind of an afterthought that you didn't pay too much attention to in the choice of law.
That's a good point. And I can see here that we did get a question, or a request rather, for me to repeat about the choice of law. And in a nutshell, what I was saying was that the choice of law is the choice of the substantive law governing the contract, and it is usually good to choose a law that the parties are familiar with. Before proceeding here to the next slide, I think I could kind of sum up the points here on the previous slide, and basically the big takeaway is that one should strive to make choices on all of the core components that I have mentioned, and do so in a clear manner that leaves as little room as possible really for ambiguity and uncertainty. Because having an unclear dispute resolution clause will often result in detrimental effects once a dispute arises, since that leaves the dispute resolution clause open to dispute in itself. And this will oftentimes delay the proceedings and might also basically affect the intended resolution of the dispute. Lise, you had something?
Yeah, I was just saying that once you get to a dispute, you're always friends when you start out a contract. Then it's a bit like the beginning of the of a marriage, and this is a bit negotiating this clause is a bit like the prenups. It's not pleasant to think about that it could ever end. But similar to a divorce, once you are in a dispute, sometimes the parties can't even agree on the color of the sky. So to have anything that you need to dispute around extra outside of the material dispute, when you come to the point of dispute, it is really troublesome. And also, you're always going to be on the good side because you're obviously the good side from your perspective. So, but there might be another side that wants to just simply delay this, that doesn't want justice to be done because they might not benefit from it. So whenever there's a possibility to stall, we're going to have parties trying to do that. So make sure you plug all those holes. I'm sorry, I keep interrupting you, Christoffer. I'm just...
No, that's completely fine. I think these are very good comments. And to the audience as well, feel free to ask any questions you might have. Right now, I don't think we have any questions, actually, so I will be proceeding here. And what I will be proceeding to is to look a bit closer on the first choice to be made when negotiating a dispute resolution clause. That is, whether the dispute should be adjudicated by way of national court proceedings or arbitration. And working at an arbitral institution myself, as you might suspect, I am quite the big believer in arbitration as a way to resolve disputes. And frankly, there are a lot of good arguments to be made for arbitration. But in this slide, I will try to still be as objective as possible and outline quite kind of the main differences between court proceedings and arbitration. And here we have the first, and that is looking to the persons who actually adjudicate the case. And looking at national courts, I mean, national courts consist of general judges whose caseload consists of a large variety of different cases, and the judges are also appointed by the court rather than by the parties. In arbitration, it is actually the other side around. The parties decide on the number of arbitrators that shall adjudicate the dispute, and will often appoint some or all of the arbitrators themselves, depending on the arbitration agreement and the applicable rules regarding appointment. And this allows for experts, or the appointment rather of experts which are specialized in the legal area or industry relevant for the dispute to be appointed in arbitration. Also, finding an arbitrator with the most suited experience and expertise is kind of a core function of arbitral institutions such as the SCC. Yes, and another central part of arbitration is, as many of you probably know, party autonomy. So the parties decide how they want to tailor the dispute to best fit their needs, as opposed to public courts where the procedure will be decided by the court. And then we have a key difference here, and that is that arbitration is confidential, whereas court proceeding, as a main rule, are public. This makes arbitration the preferred form of dispute resolution in many business relationships, perhaps especially in international business, where the parties have an interest in keeping their trade secrets, relationships, or disputes confidential. But on the contrary, I mean, in some disputes, the parties may have an interest of judicial decisions being public, and if this, in fact, is the aim, then public courts may be a better path. But in my experience, I would say that in a commercial context, publicity of disputes is usually not that desirable. The next thing we have here is international enforceability. That is the possibility to enforce an arbitral award versus a court judgment. And then enforcing it in another country than where the arbitral award was rendered or a court judgment made. And due to the New York Convention, which is an international instrument, an arbitral award will be internationally enforceable in more than 150 countries. The enforceability of a court judgment, on the other hand, will greatly depend on the country where the judgment was made and the country where it is to be enforced. And in many jurisdictions, a court judgment will only be enforceable in that country or within the European Union. Oh, I see you didn't see the point. Let's see. There it is. So this brings us to the next point, and that is that an arbitral award is final and binding, which means that as a general rule, it cannot be appealed on material grounds, even if the appeal is based on an alleged error in fact or law. And generally, an arbitral award may only be appealed or challenged due to procedural errors and on very limited grounds, really. A court judgment, however, may be freely appealed due to the structure of national court systems, and I would say that it is quite common for court judgments to be appealed by the losing party, simply because they are not happy with the outcome. And this means that court proceedings stand the risk of appeal, and therefore a greater loss of time, so to speak, before the dispute is finally settled. So arbitration is more of a one-stop shop, which is generally a quicker method for dispute resolution. And talking about the quickest method for dispute resolution, the expediousness of arbitration is not only due to the award being final and binding, but also because there are time limits for rendering arbitral awards. And the parties will agree with the arbitral tribunal on a timetable for the hearing and the termination of the arbitral proceedings. I would say that this is also especially the case in institutional arbitration, which usually has rules that stipulate a time limit for the rendering of the award. So yeah, every case is individual, but it will usually take a lot longer to go through a national court system than adjudicating a case by way of arbitration.
Can I throw in an example there?
Sure.
I mean, it's really hard to compare case to case because they're differently complex. They deal with different things and so on and so forth. Every case is a unique snowflake. However, we asked the law firms here to compare what they sensed, if they tried to find comparable cases, how long they took in arbitration compared to in the national courts. And some examples we got were large cases. So in arbitration, you see between 6 and 12 months as some sort of a standard. And so this was a case that they compared that was 3 years. So that would be one of our big cases, and a comparatively in size and in complexity that went all the instances in the national court system took 13 years. So from 13 years to 3 years is obviously a huge difference. So that's one example, and they don't all go all the way up to the Supreme Court, which is a hefty delay when they do. But that's one of the examples that they gave.
All right. And then finally looking to another factor, and this one tends to be, I would say, a main consideration in most business dealings, and that is costs. And I would say that a fairly common conception is that the cost for arbitration is higher than the costs of court proceedings, since the parties are required to pay the arbitrator's fees and the fee to the arbitral institution. And for now, I think I will suffice to say that in many disputes, this is probably a misconception, and I will be elaborating a bit more on the topic of costs further down in the presentation. So that concludes this slide, and I think the next one is you, Lise.
I think so. Okay, so I'm going to talk about the difference between ad hoc and institutional arbitration. So for the remainder of this presentation, we're going to assume that you chose arbitration, not just because we think it's such a great tool, but because most of the choices that you make after that selection is related to arbitration. If you have chosen a court, as Christoffer mentioned before, there aren't that many choices that you can make. It's rather fixed. Good and bad, it's rather fixed. So we're going to be talking about the choices now that you make when you have arbitration. So talking about ad hoc or institution, I must admit I had no idea what ad hoc or institutional was before I started here. I'm not sure how familiar everyone is with the concept of arbitration, but essentially what it means is either you have an administrative body, an institution, that handles the case for you, or you have a DIY, do-it-yourself type of proceedings, which is the ad hoc. So the ad hoc proceeding means that the parties themselves, they go together and they agree on the various aspects that needs to go into this, who to appoint and so on and so forth. This sounds like High Chaparral. It really isn't. This has been around for 100 years. There's a lot of best practice brought out within ad hoc as well. We come from an institution, and we obviously will argue the benefits of an institution because there are many, but ad hoc is also, it's something that is used predominantly in certain countries and in certain industries. So the difference between the two, concretely, is, as I mentioned here, either the party will administer the case or the institution will administer the case. This also means that when you have an institution, you have a schedule of costs. It sets out exactly how much everything from the institution and the arbitrator's side will cost. And it is, for most of the big institutions like us, it is based on the value of the claim. So if your total claim is X, then the fee is going to be Y. And there's a calculator on the web page, on our web page, and on many of the other institutional web pages, where you can see exactly what it's going to cost, or at least exactly, unless there's any unforeseen aspects. Where there's an ad hoc, the arbitrators, they decide themselves. When you have an ad hoc, what you fall back on is the local land, the land's law on arbitration. So every country that has arbitration as a tool has some sort of law regulating it, and that one has quite limited amounts of procedural tools. Whereas if you go to an institution, one of the main sort of products that we do is that we provide you with a procedural toolbook with the rules that will tell you how this process should go on and what kind of extra tools you have to make sure that it runs smoothly. There's a default for 3 arbitrators. If it's ad hoc, you can agree to have just 1, but there's a default of 3, which obviously comes down. The difference between that is one of the aspects that comes into that, of course, is cost. 3 costs more than 1. Under institutional, it's usually that the ordinary arbitrations, they will have a default for 3, but you have expedited arbitration that will have a default for 1, or that will have just the 1. Then you have one of the core aspects here is, of course, is the arbitrator bias. And especially if you're talking about industries that might be quite tight-knit, you might have a fairly small pool of experts. As Christoffer mentioned before, one of the benefits here is that you can get experts. One of the risks with that is that if you're an expert within a field, there's also a big risk that after a long career in that field, you have quite a lot of ties to the industry. So handling challenges on bias is one of the core aspects that the institution does. If it's ad hoc, the arbitrator will do this themselves. And another aspect is if you need interim measures, if you need to put a stay on something, then you need to go to a public court if you're an ad hoc, which means that one of the core aspects here, which Christoffer talked about, confidentiality, it's harder to maintain that in a public court, of course, but if you go to an institution, especially SCC, not all institutions, but SCC and a lot of others will have an emergency arbitrator that will provide you with interim measures also under the confidentiality seal. And we have the ability to essentially cut pay if they don't behave, which is mainly a way to make sure that they stay on the time schedule, that there's no undue delay. If there are undue delay, or if there's any other mistreatment of the process, then one of the tools that we have is to actually reduce the fee of the arbitrator. So that's a little bit about ad hoc or institution. Just checking here if there are any open questions. No, we have one question that I will answer towards the end. If there's anybody that has any questions, please do add them in there. Okay, moving on then. Sorry, this is still me, right, Christoffer?
It's still you, yeah.
There we go. Okay, so if you then choose to have an institution rather than an ad hoc, you need to figure out which institution to choose. So there's hundreds of institutions out there. They are either specialized regionally, or they can be specialized within a field, or you have a number of them that are global. The Stockholm Chamber of Commerce being one of them. On the left-hand side here, you see a list of the biggest ones around the world, global institutions that are all really good. And I obviously represent one of them, but I can easily say that regardless of which one you take of these ones and a number of others, you're going to be fine. They're all really high quality institutions that will get you to where you need to go. The main difference between us is where we're based. So it will be quite often the choice of institution will be coupled with the choice of seat. As we talked about before, the seat is important. Now you can have Stockholm Chamber of Commerce and use Paris as a seat, but they tend to kind of go together. The other is, of course, the legal system. And this is important mainly if you have done that previous couple, that you have the seat as well. And if you choose, for instance, the Stockholm Chamber of Commerce and you say nothing on seat, we will assume a Stockholm seat. And the same will often go around the world. So that's important to keep in mind. The other one is the rules. So we all create our own set of rules. They are, which is this procedural rule book. Now, to be entirely honest, they're quite similar when it comes to all of us big ones, because if we see something good, the rest of them tend to pick it up. So they've become quite harmonized over time. There are some things that go this way, some things that go that way, but overall, we're quite harmonized. I take some pride in saying that we have come up with a couple of things that have spread through to the other ones. But generally, if there's a good thing that comes along, then it will be picked up. So that is the rules, of course, then is the list of the procedural tools. But then you also have the level of administrative support. So how involved is the institution? Now, one of the aspects here is, for instance, do they go through the award before it's being rendered? So after the arbitrator is done, some institutions have him or her send it through to the institution. They review it before they can send it onwards. That's called scrutiny. And some institutions do. ICC, for instance, it means it takes slightly longer. We have a fairly light touch. We don't have that step, so it is rendered immediately when the arbitrator is done with it. And generally, time is an aspect that is slightly different between these. So we're fairly similar. ICC sticks out a bit. It is their average is about twice the rest of us. That is probably a combination both of scrutiny and, for instance, they have big cases that tend to take longer. So it's not a straight line between what the average that the institutions have, of course, and how long it would take your case. And then it's cost. We have different cost schedules. We're fairly harmonized, but for instance, London LCIA have they pay per hour instead of, or per day instead of per value. So it's an entirely different business model. And then we of course have different scales. SCC falls on the cheaper side here when it comes to our competitors, but it is, as Christoffer will come back to, this is not going to be a core determinator of your cost related to the case. And that was my nice segue on to you, Christoffer.
Thank you very much. So I'll just change the slide here. And as promised in the beginning of this presentation, and as per Lise's beautiful segue, I will now be returning to the topic of costs, because as I mentioned, this will usually be a consideration in most commercial contexts. And I also mentioned that there probably is a conception that the cost for resolving one's dispute by means of arbitration will be higher than choosing court proceedings, and that I would argue that in many cases this is a misconception. So first off, what are the costs in arbitration procedure? Well, we first have the counsel fees, which are of course a cost in any form of dispute resolution where parties have legal representation. Second, we have the costs of the arbitration itself, and these costs are made up of arbitrators' fees and also expenses, and if institutional arbitration is chosen, the fee to the arbitral institution. So having established that, we can have a look at the figure on this slide. And the numbers on the figure show which costs represent the most money in arbitral proceedings. I should be mentioning as well that these exact numbers on the figure are a couple of years old, but the proportions still kind of hold true. So as we can see from this figure, counsel fees are by far the biggest cost. They represent about 70 to 85% of the total costs in arbitral proceedings. Only 15 to 30% are represented by the cost for the arbitration. So considering then what we talked about before, namely that arbitration will generally be a quicker way to resolve dispute than court proceedings, and that arbitration is a one-stop shop with very limited possibilities to appeal, counsel fees will generally be smaller in arbitration since the proceedings are shorter. That being said, there is of course a cost threshold in arbitration constituted by the fees of the tribunal and the arbitral institution, meaning that it perhaps might not always be the best option for very small disputes where there will be no or close to no counsel fees. Yeah, arbitration costs, exactly. And besides the length of the proceedings, there are a few other cost drivers as well to consider. And these includes the seat and the choice of law, which goes back to what I talked about initially. So if the arbitration or contracting dispute is governed by a law unfamiliar to a party or the parties, the fees for contracting local counsel may, for example, contribute to higher costs. Likewise, I think that it is quite well known to everyone that lawyers in some jurisdictions charges higher fees than in others. So this is also something to be considered when choosing the seat and applicable law. And also another reason as to why it is important to, as Lise talked about, consider all of these factors when drafting the dispute clause.
And of course here, if you have one material law and one seat and another institution, then all of that is entirely possible. And it's important to know that you have that toolbox to be able to be that flexible, but it will be a cost driver if you spread out too much, because you will then need to double up with extra lawyer teams that will understand the various components. So that is, keeping it all collected is a smart way from a cost perspective.
Yep. So I have already talked about a bit a bit about the importance of choosing the right seat in the arbitration clause. And I will now be talking a bit more about that and talk about some key aspects to consider when actually choosing the seat. Some key aspects. So, as I mentioned before, the seat of the arbitration governs the rules on enforcement of the award, and therefore the first and probably most important aspect when choosing a seat is that the country of the seat is a party to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And as I briefly mentioned before, this is a very successful international convention that has over 150 parties, and it allows for the enforcement of an arbitral award in another country than that in which it was rendered. So if the chosen seat is a state which is not a party to the New York Convention, there really is no guarantee that the award will be enforceable internationally. So this is something to consider. But as mentioned, a lot of states are in fact parties to the convention.
What might be relevant to remember, and maybe I'm cutting into your next point, I hope I'm not, but is that even if you are party to the New York Convention, some countries have chosen to have various exemptions. So you may still need to just check out that they are a clean party, so to speak. But generally, this is a very low threshold to climb over.
Yep, that's true. That's something that needs to be checked as well. So the next aspect to consider is whether the national system of the seat has arbitration-friendly courts, or actually an arbitration-friendly system as a whole, with arbitration-friendly legislation and national authorities. Because different jurisdictions have treated arbitration in different ways. So it is important to choose a jurisdiction where an arbitral proceeding and arbitral awards are protected. And the most important factors to be considered here is finding a jurisdiction where national courts will not intervene in the arbitral proceedings and will let the arbitral award be standing and final. So that is not to change or overrule any material aspects of the award. Also here, our arbitration-friendly jurisdiction will generally have a more solid body of case law and jurisprudence as well, in case that the arbitral award should be appealed or challenged. So another aspect that you will generally want to consider when choosing a seat is the levels of corruption, and you generally want a low level of corruption. So that is a jurisdiction where national authorities and national courts will not intervene in the arbitral proceedings on unjust grounds or otherwise take unjust actions which may affect the proceedings. Another point here is that it is also beneficial to have a strong arbitral institution in the seat of the arbitration. And this will usually mean that the national legal system is used to and perhaps even friendly to arbitration, since the court and authorities have some experience of arbitration taking place on their soil. Likewise, the law firms in that jurisdiction will probably also have more experience with arbitration, so it might be easier to get quality legal representation along with a good pool of arbitrators. And speaking of arbitrators, a strong arbitral institution will also have good connections with the legal community and therefore be able to appoint a good arbitrator comfortable with the proceedings. And then we have the cost of legal representation. And I think I mentioned this briefly before, but the cost of legal representation will, of course, be different in different jurisdictions. So this is also something to consider. And then the final point here on this slide is that if the seat and the place for the hearing of the arbitration is the same, you will want to consider the geography of the seat in relation to, for example, the parties, and see to that the seat has good infrastructure in terms of good communications and facilities for conferences and hotels and so forth. And as we have mentioned before, the seat and the place of the hearing in the arbitration is not necessarily the same place. But most of the time when drafting a dispute resolution clause, the intention is that the seat and the place of the arbitration shall be the same. So, taking all of these aspects into consideration, I would like to just briefly touch upon whether something can be said as to the rankings of different arbitral seats. That is, if we can see that some seats are general top choices in international arbitration. And of course, this sort of ranking is not set in stone and will be subject to a number of factors depending on the case and circumstances at hand. And surely some degree of subjectivity is also unavoidable when talking about rankings such as this. However, we do have in a book compiled by one of the biggest law firms in Sweden, the seats here on the left side of the slide. And these seats have been ranked among the best arbitral seats globally. And the seats on this list are generally jurisdictions which have kind of stood the test of time when it comes to arbitration and which do not contain the risk factors to be considered when choosing an arbitral seat. So these are seats which are generally arbitration friendly in terms of courts and legislation. They have perhaps strong arbitral institutions, low corruption, and good infrastructure.
I should say as well, there's obviously, just as there are with institutions, and we've chosen to highlight a few, there's a long tail of other really good ones that just might be just under that cuff, but are still really good ones. So I'm sure if you scrutinize this, you'll think maybe of some cities or places that you might be missing that are just under the cuff of what they ranked as, star. So this is not to be seen as an exclusive list in any way.
Perfect. I think that's it for this slide, and the next one should be Lise.
Exactly. And now, so we have now talked a little bit about what you should be doing, and I wanted to bring up some aspects about what you may want to avoid. And there's a number of different things here, but to start with, mandatory escalation or alternative clauses where you might say that, okay, we need to first negotiate, or we need to first mediate, or we need to first do something else before we can go into to arbitration or to litigation. Now, these can be risky. So there's way to do this that isn't problematic. But the reason why this can be problematic is that if you have one of those clauses and you have not taken all the steps, you want to go straight to litigation or arbitration for whatever reason, then they might be considered to be a hindrance of going to arbitration or to court. In Sweden, this is generally not an issue, but there are jurisdictions where this might be an issue. Another flip side of this coin is that if the clause essentially said we will negotiate first, either you are in a friendly enough place to be able to negotiate without having it in writing, or you are not in a friendly place where such negotiations might not be that effective. Now, this is of course also truth in moderation, because there is some ways to actually honoring the contract of trying to negotiate first, but be a little bit wary so you don't make them mandatory in this type of contract. And I think hopefully that also answered one of the questions that we had earlier from one of the audience. Another aspect what we sometimes see is a very detailed regulation on who should sit as arbitrator, who should be in the tribunal. So you might have an idea that, okay, we think that if we have this contract, we're probably going to be fighting over this, or that, because that's the most sensitive thing. And we know that the only three people that know this well enough for us to be comfortable with is him, and her. And so you make a description that is essentially them. Now, when the dispute actually arises, it may not arise in the area that you thought it would. It may have been on something entirely different, which means that they might be the wrong experts, or they may not be available. So there's a number of reasons why it could be a good way. It could feel like a good way when you write it, because it may get you to move past the hurdle in the negotiations, but come dispute time, it's usually better that this is decided upon when the dispute has arisen, and then by the institution that is neutral in this. There are certain multi-forum clauses, and with this I mean that you have, say, quite a classic one is up to amount X go for court, above amount X go to arbitration. So these can be problematic they're quite attractive in that they address the issue that Christoffer said, which is small value claims. They don't really belong in arbitration because the threshold money is still there. There is a threshold fee that will make arbitration less appealing in small value claims. So there's definitely an attractiveness to this. One thing to just bear in mind is that courts and arbitration is exclusive. If it says in the contract it needs to go to arbitration, the courts can't touch it. Same goes on the other way around. If it says it has to go to court, arbitration can't touch it without the parties having agreed to changing this. So if you don't then have a party that doesn't agree, which we already talked about that they rarely do, then what you can have is you have a claim that is on, say it's $1 million, that is the cutoff. You have a claim on 900, so then you get a counterclaim that pushes it above. That means that you have to move forum. You have to go from court to litigation, and then they withdraw the counterclaim. It moves back under again, and then can go back and forth again on who is actually has the ability to handle the claim. Another aspect is quite often you'll see a grid of contracts that all kind of touch upon the same thing. So if something happens in one end of this grid of contracts, it will affect all the other ends, and it might be some sort of you might need to sue under several contracts and maybe under several party constellations and so forth. Now, there are ways to make sure that you can have an effective and also cost-effective process here by joining these together and actually deal with them as one case. But for that to be possible, they have to have the same clause. So if you have slight variations of the clause in these grid of contracts, then that opportunity falls away, and you may need to arbitrate the same issue in several different types of contracts. And so copy-paste is my best tip there. And next one here is pathological clauses. Now, this was a word that I reacted to a little bit when I started. Essentially, it means bad clauses, clauses that are written in a strange way. So we see quite a lot of these when there's essentially somebody has taken a tumble of words that sounds like litigation words, and they just string them together, and it doesn't necessarily make sense. So essentially, and then it becomes really hard for us to see, okay, what was actually intended here? Is it actually a court case? Is it actually arbitration? We have some rather funny examples of this, but some of them require understanding of Swedish, so I'm not sure they will go over with everyone, but I'll still take one of the more funny ones we have seen is in case of twist, which in Swedish is the word for dispute. In case of twist, you have to go to Danish arbitration, which essentially means if you need to dance, you have to go to Danish tree cutting. And that one is more funny than problematic because we understand what it means. But you have quite a lot of examples where we simply don't understand what it means. This all boils down to what we could have said in the beginning of the hour and then afterwards let you all go, which is just use the model clauses. The simplest, fastest way to do this is just copy and paste. Go to either institutional websites. We have ours here, but all of the institutions will have this, and copy and paste the model clause that is in there. They are carefully drafted. They've tested over and over and over again, and we know that they work. So just copy and paste. So coming up on the hour here, I'm going to bring up a couple of things to remember. So if you leave this and you forget everything that me and Christoffer said, bring this with you. Arbitration, one of the core aspects here is that it's internationally enforceable as opposed to courts. Another thing is that it's usually more cost effective, at least in larger cases, than courts. Use the model clause up, make life easy for you, copy and paste it. Hold on to your seat. Even if you use a model clause, there will be you can insert the seat of your choice, hold on to it. And if you choose any of the top ranked institutions, you're not going to go too wrong. It's going to work out fine. All right. That was us at the end of the slideshow. And I know that we have a couple of questions. So I'm trying to see here. So a few of them. If there's a list of the countries that are not part of the New York Convention, is one of the questions we have. I haven't seen the list as a negative list. I mean, the list of the parties that are party to the New York Convention is obviously, you can find it in multiple places. The key source would be, I assume, the UNCITRAL, which is the UN organ that has brought out this convention. So United Nations Trade and Commission on Trade, International Trade and Law is that body that holds this convention. On their website, I would imagine that you can find the list of the parties to the convention.
Yeah, that's correct. You can find both the list of the parties to the convention and also the status of the convention. So in terms of signature and ratifications and some information on reservations as well, I think.
And the other aspect here is a question was just on what does MSA stands for, and it's one of the biggest law firms. It's Mannheimer Swartling, one of the biggest law firms here in Sweden. I think it's the biggest. We have a question as well on whether or not Hong Kong will hold their position given the latest political situation. I think that's really interesting to follow, and this is when it comes to what institutions are the big ones from an international perspective. The big political movements are really at core of where you choose which ones pop up as popular. The reason why Sweden is as popular as it is because of our historic neutral position. So, I mean, we popped up during the Cold War when the US and the former Soviet Union decided to use us as the hub for all commercial disputes, and that kind of spiraled us into the international scene. Now, obviously, as some of the focus on East-West may move over even further east, then there are other institutions such as Hong Kong that have held a stronghold on being a hub between East and West when it comes to Asia for a long time. They have a very natural position there. Singapore is actually a fairly new institution by our standards. From the beginning of the 1990s, has come really strong as well. So whether or not Hong Kong will hold their position given the latest political situation, it's hard to tell, but you need to weigh in also the factor that China is becoming a bigger and bigger player, and Hong Kong is still some sort of a hub there. So we'll just have to wait and see. I think I have, or we have answered. Let's see. We have one more question. I feel this is one for you, Christoffer.
Yes, I'm just reading. Let's see, necessity take some time.
Am I reading the question?
Case in point. Sorry, I'm just trying to read the question here.
I realize the entertainment value of two people figuring out a question might be fairly low, but
yeah, not very high, perhaps.
Bear with us for a few moments.
So I guess the question is, if I understand it correctly, whether the SCC takes into account the substantive law in a dispute when appointing arbitrators, and the answer to that question would be yes. That is one factor that is certainly considered.
I mean, that's one of the key factors, I would imagine. That
it is. We're looking at a number of different factors. I mean, the nationality of arbitrators and the substantive law and the kind of the disputed subject matter. But the applicable substantive law is definitely one of the key factors.
Okay, I don't see any more questions unless I'm missing something, which means, and we just hit the 3 o'clock mark here in Stockholm, which means the sun has almost set. And our webinar is also up. So I want to thank everyone for joining. We will be sending out this presentation afterwards to all of you. And there will also be a recording available if you want to visit back. And naturally, me and Christoffer are available if you have any questions. You can just email us, or you can email arbitration@chamber.se, and it will be forwarded to us. So with that, I wanted to say thanks all, and I hope you have a great continued Thursday.
Yes, thank you all very much.